NACDL is the association of the nation's criminal defense bar.
Good afternoon, everyone, and happy Public Defender Day. My name is Patrice James, and I am the co-founder and vice chair of the Black Public Defender Association. I am very excited that BPDA has been able to partner with NACDL for what I imagine will be a very powerful discussion. BPDA is one of the first Black-led associations dedicated to the advancement, development, and support of Black advocates, lawyers and non-lawyers, working in defender offices, civil rights and policy firms, civil legal aid offices, and grassroots organizations across the country that are committed to fighting against the destruction being caused by mass incarceration. BPDA nurtures a national coalition of zealous Black defenders, shaping the narrative and leading the fight to dismantle these carceral systems. We fight for a world where Black people and Black communities have the power to control their resources and their own destinies. I am very excited to listen to today's conversation on race and public defense with BPDA board member Portia Venable and founding BPDA member Adiola Angukayade, and also my two former colleagues, both of them my former colleagues at the Bronx Defenders, who I am deeply and proud of and love very much. I'm so grateful to be here. And to listen to everyone, including Matthew. So welcome.
Thanks, Patrice, for that warm welcome. I'm definitely glad to be amongst friends. We're together, obviously virtually, but transcending the space to be able to at least have this conversation feels just like I'm in the company of great friends. So let me take a moment to introduce, my new fave and one of my old favorites. She's not old, but my new fave, Dr. Matt Clare, is an assistant professor in the Department of Sociology and on loan to the law school at Stanford University. His research broadly examines the law, race, culture, and inequality. Dr. Clare's research and writing has been published or is forthcoming in Criminology, Social Forces, California Law Review, The Nation, Boston Review, and other scientific and popular outlets. He has received funding from the National Science Foundation and awards from the American Sociological Association, the American Society of Criminology, the Law and Society Association, and the Society for the Study of Social Problems. As I said, he is my new fave. Matt, don't get freaked out. I'm reading all your stuff and kind of obsessed with you right now. Thank you for joining us today. And one of my longtime faves, dear colleague and friend, Portia Chiffon Venable, who was born, raised, and still resides in the Bronx, where she does the best work that I have seen of an advocate in this space. Portia Chiffon received her Juris Doctor from California Western School of Law and her Master's of Social Work from NYU School of Social Work. She will be the first one to tell you that she is a social worker who also happens to be a lawyer. She started her career at the Bronx Defenders as a forensic social worker, in fact. During law school, she returned to the Bronx Defenders as a law clerk, and after law school, she was a staff attorney in the criminal defense practice, the Adolescent Defense Project, and a team leader. In 2017, she joined the Neighborhood Defender Service of Harlem as a staff attorney, and then returned to the Bronx Defenders for a fourth time in her career, where she now serves currently as a supervisor and again, a team leader. So thank you, Matt and Portia, for being here, for joining me in this conversation. I'm so excited to have this dialogue with you all right now. So, I will start with you, Matt. It's your scholarship, right, that brings us at least together in terms of providing a focal point, right? Your recent book, Privilege and Punishment: How Race and Class Matter in Criminal Court. It has been, for me, a wonderful read. And I'd love for you to talk to us a little bit about, the impetus for the book and the central lens that, we find in that work.
Well, thanks, Adiola. The obsession runs two ways as a new friend as well. Also, I'm so happy to be excited to be in conversation with Portia Siobhan as well. And thank you so much to BPDA and NACL for just making this conversation possible. The book really sort of emerges from, as I was a graduate student and researching courts and inequality and really motivated by the movement for Black lives and sort of being in the protests in the streets starting in 2013 after Trayvon Martin was killed and George Zimmerman was not convicted of murder, just trying to understand how in the world do we have a court system that routinely every day pulls Black young boys and men into the system and incarcerates them for far less than what George Zimmerman did to Trayvon Martin. And so for me, as I was entering research on the courts, I was reading a lot about the courts in relation to politics, laws, empowered actors in the system, prosecutors and judges. But I was curious how people impacted by the system, so defendants in particular, how do they make their way through the system? And what does the quality of justice feel like for them? What do they want from the legal process? And so as I started doing data collection, I really centered their voices. So I did interviews and observations among 63 defendants. I did over 200 hours of observations in the Boston area court system, in the Boston municipal courts, as well as in 2 superior courts in the Boston area. And then I also embedded in a public defender's office in Boston and really was able, wonderfully through the access of the Committee for Public Counsel Services, afforded me access as an unpaid intern to really observe attorney-client interactions in real time. And so what I came to learn was that for defendants in the system, and the lens that I develop in the book, is that so much of the court process is filtered through and mediated by their interactions with their attorneys. And so the feeling of injustice and inequality really is felt through that relationship. Coercion, shaming, not just from judges and prosecutors, but also from their own defense attorneys. And so seeing how they felt controlled by people who are trying to and are well-intentioned in trying to protect their legal rights. And then also because I centered focus on defendants, I got to talk to defendants about how they felt about their lawyers and the things that they wouldn't directly tell their lawyers. And so I hope in the book, I'm also able to unpack, how people who are impacted by the system think about inequality and injustice, the personal histories that they carry with them throughout their lives that influence the way they view the court system and what they want from the court system. And the last thing I'll say is, I finished writing the book, turned it in to the press on March 1st of 2020. So this was, of course, before Breonna Taylor was killed, before George Floyd was killed, and before, the protests this spring and summer that really have centered a lot on the problem of policing in the United States. But also we can see in George Floyd's life how much he was controlled by the court system in the legal process more broadly. And in Breonna Taylor's case, we know that, she was pulled or the detective was able to go, and then the police department was able to go to her home because of a no-knock order, right? So really understanding how the courts justify the abuse of police, and then also how courts themselves have techniques and tools of legal control that are also problematic and are indicative of problems of the broader carceral state, not just policing. So that's kind of where I'm coming from in this book, and that's really sort of the conversations that I want to unpack in more detail through this work.
Yeah, no, I mean, it for me was like revisiting so much of my career from just a different angle, and having a relationship that I have navigated myself as an attorney with a client narrated back to me through your voice and your lens, felt impactful in a different way for me. And so I'm deeply grateful for having this work out there so that, I can engage with it in a different way. I can engage with that relationship in a different way. And also for folks who don't have any insight into the way the court system works and the ways in which attorney-client relationships are so complex, right? I want to hear from you, Portia, right? Obviously, I have my reaction, but I'd love to hear sort of like, how it felt for you, reading this book. I know you're a fan of Matt's work, and what your reaction is to this work on the much needed work that you do as a defender.
It's interesting. When I first was asked to do this panel, I got a brief synopsis of what the book was. And my first thought was, is he coming for us? I was like, wait a minute, and it's interesting. So before I even read his book, before I read Dr. Clare's book, I looked up some of the other pieces that he wrote. And as you've already stated, and it can't be stated enough, I am a huge fan. And so much of the work that he's written really sort of honing in on the ways in which our system fails, and the ways in which individual state actors fail is incredible. And so, I looked at some of the pieces he wrote about abolition in court and the way that courts function as sort of this vessel of police brutality and white supremacy and systemic oppression. And I was like, okay, I can sign on to that. And I started reading the book. And, this book is written from our clients' perspectives, and oftentimes I found that when people want to do pieces, whether it's videos or a written piece on our client's perspective, it tends to be, who's the most mentally ill. Like the person that's looking to do the story often is looking for the spiciest story, right? And are looking to see who's the most violent, who's the most mentally ill. And it can often feel exploitive and voyeuristic. But this book, I saw so many of my clients' experiences and stories. And Dr. Clare is right. I feel like we besties now, so I could call you Nat, but for the people, I'm going to call you Dr. Clare. But Dr. Clare was right when he said, our clients were very frank with him in a way that I don't necessarily think that they are as frank and upfront with us about how they're feeling about what we're doing, and they're very raw and real experiences and perspectives, whether it be with us, whether it be with police, whether it be with any part of this really reprehensible criminal legal system, it deserves to be told, and even grass grows. And I saw this book as an opportunity to grow. So thank you, Dr. Clare.
I appreciate that. Can I just follow up? I think, so first, Portia Chiffon, you can call me Matt. Anyone can call me Matt, by the way. Feel free to if you email me. But, I think, when I was writing this, clients were super frustrated by a lot of their lawyers. But, in the book, I do also talk about clients who weren't as frustrated by, their interaction with their lawyer and the privilege, right, that was embedded in that kind of relationship and what brought that kind of relationship about. And, the public defenders I got to know, the three in particular who I talk about in detail in chapter 4, Tom, Selena, and Sybil, they are hardworking. They care a lot about their clients. They came into this work because they cared first and foremost about racial injustice and inequality. And the problem is they're caught between the expectations of their clients and then the reality of a legal system and the norms and institutions, as well as, of course, constitutional jurisprudence around the Fourth Amendment and things like that, but also the norms of the courts and the reality of having to deal with and help multiple clients, not just one client. And, that reality meaning that maybe you can't fight as hard in certain ways and use certain legal procedures for certain clients. And so I'm really trying to, help public defenders see this sort of more systemic level inequality that I'm sure many are aware of, but also see how it unfolds through the eyes of their clients, as you so wonderfully articulated for me.
Yeah, I mean, it is a complex relationship, right? The attorney-client relationship. There are so many dynamics that are at play and so many things that I think, as an attorney, I'm navigating, but I also know that my client is navigating at the same time, and we bring all of that to each other as human beings, right? All human relationships are complex, right? And we bring so many things to the table, and yet the particular crucible, right, of the courtroom, of the court case, is something, apart from anything else. So, Portia, tell us a little bit, right? Obviously, the book, as Matt says, is written from the perspective of the client, and to the extent that in this conversation we don't have an actual client present, right? I know that space is one that rightfully belongs to the clients in the first order, in the first instance, to really be able to say and talk about what their experience is. But I'd love to hear from you, Portia, to start from the attorney perspective. And unpack a little bit of that complex nature of the attorney-client relationship.
Well, I guess the first thing I should do is give the attendees a qualifier, right? Is my baseline is holistic defense. I am, born and bred as a holistic defense attorney. And what that means is that I take a very client-centered approach to my legal representation. And that means that I am employed in an office that comes from an interdisciplinary approach. And what we try to do in holistic defense, or with holistic defense, is really address the reasons, right, that drive our clients into the criminal legal system. And we don't just try to acknowledge them, we also try to employ different things to address them, right? So for example, if I have a client that has been arrested for 3,000, for stealing, 30 bars of soap, nobody is that clean, right? And so that to me is sort of a red flag that there may be something more there. And so what that requires is me to have a real conversation with my client. And normally what those conversations reveal is that my client may have a substance abuse problem, right? So now I'm not just looking at trying to get them up from under the criminal legal system. I want to potentially help them, if they're ready, to address their addiction. And that's really what holistic defense means. It means that I am not just walking in and, resolving my client's case. If my client is open, to further assistance, then I have the resources to sort of, direct them to those different things. And so when I'm talking about the way in which I view client relationships or my particular legal representation, I'm definitely coming from a holistic, client-centered approach. And just sort of to piggyback off of that, when I'm saying client-centered, it means that I am coming from the perspective of, what my client wants to do is what I am going to do. My clients are brilliant. They have agency. And they are the ones that are going to have to deal with the good, the bad, and the ugly of this criminal legal system. Now, don't get me wrong. They don't call me counselor for no reason. And so that doesn't mean that I am just like, here, vayas con Dios, go with God. I definitely, talk to my clients and advise them about, again, the good, the bad, and the ugly of their generally crappy choices. But it is up to them what happens, because it is them who are going to have to deal with the outcome of this case. So that's my perspective. And if you don't have the resources, or if that's not your perspective, that's fine, no judgment here, but I just want to be frank with the attendees that is my baseline, and that's where I'm coming from.
No, thank you for that. And Matt, obviously hearing Portia in this context as an attorney speak on sort of like what client-centeredness means to her, and the ways in which her foundation in like holistic defense, looking at the client beyond just like the case in front of her at the moment, how does that jibe with, what you were hearing from, the interviews that you did in service of the book, and how that informed, the ways in which you framed your analysis and framed what you were seeing and learning.
Yeah, absolutely fantastic. I love that you, Portia, Siobhan, sort of said where you were coming from. And I think this is super important, right? So obviously with the indigent defense system as a whole, we have public defenders' offices, and then we have, the majority of indigent clients who don't have public defenders, who are salary government employees. Instead, they are often, and in Boston, for example, 75%, there's a 3/4 chance, or there's 75% chance, 3 out of 4 times that you're going to get not a public defender, but someone who's in the private bar and is a bar advocate, as they call them in Boston. They're trained by the broader sort of public defense association throughout the state, but they have different resources. And I think, Portia, Siobhan said resources, right? That's super important, is that often public defenders' offices have different kinds of resources. And of course, public defender offices are by no means the same across the country, right? A public defense office, where you are in Travis County is going to be different from the Bronx defenders with the amount of resources that they're afforded by the state or the city and the jurisdiction, right, that they're practicing in. And I think holistic defense, bringing in social workers, bringing in other people who deal with the correlated adversities that clients are facing, right? The issues that they're facing, substance use disorder or being unhoused, is really important, and has nothing in many ways other than slotting them into the legal system, has little to do with actually, right, the specific legal outcome that the lawyer is working toward, right? And so, in the book, I actually draw on examples like the Bronx defenders and others, and also some of the ways that client-centered defense is happening in Boston as well, to say this is a practice and these are the resources that are needed to make this replicable throughout the United States. And then also this solves a lot of the issues and problems that I highlight and unpack in the book, with respect to clients being upset that lawyers aren't listening to them, that they're minimizing and delegitimating their, what I refer to as cultivated legal expertise, or their ideas about, rights that should exist in practice, or that should exist ideally, and that constitutionally sort of we could imagine should exist, but don't in practice. And I think that often if we really sort of centered clients even more, I say we, I'm not a practicing attorney, if you all centered clients even more in many ways, and many of you are already doing this, but it allows for new visions of rethinking the way the law could work, right? I think a lot of times, and a lot of the lawyers who I talk to, they're so focused rightly on helping that specific client that they're working with, that they forget that there are often ways that they can push beyond impact litigation, even that they can start to push practices on the ground in trial courts. And I think that's really important, to center clients in that way in the work that lawyers are doing.
I think even as I sit here, right, having, practiced what I consider to be, right, client-centered representation, and, having done that in a full and robust holistic context, and now trying to build out some of those similar types of dynamics here in this new office in the capital of Texas, right? There are even still days where I have to sit back and I have to take in and soak in what I've learned and heard from the men and women that I represent, and check myself, right? And check myself, and I think I'll be worried when I stop that, right? When I stop sort of like realizing, like, you got to check yourself, Adiola, based on what you're hearing and learning, to figure out like what is the right path forward, right? The law is just a lens that can be shaped and bent towards the will of many different people, including our clients. And so how do you do that in a way that provides them with the quality representation that they need, is always something that I think I want to pay heed to. And I think, right, where you say, Matt, right, that lawyers, we're so in the moment, right? We look at the law, we read the law, we have to unpack the law, and like that's our central lens, right? Because that's sort of like the identity we get saddled with, right? When we come into that space, we're the lawyer, you are the lawyer, and so you should know these things that have been sort of like put in the box for you to choose from, and nothing outside of that, feels relevant until you make it relevant. And so, I want to spend a little time talking about like identity, right? Because as lawyers, that's an identity that we bring to the table, but it's not our only identity. And for me, right, it's not my primary identity. And, you know, there are a lot of intersecting identities that I bring, you know, to being a lawyer, to being a Black woman, to being, you know, a first generation immigrant on my father's side. And so, you know, I want to spend a little time on identity, intersectionality, and like the way that plays out in courtroom dynamics, or really in the cases where, you know, clients and attorneys are interacting. So, you know, I'll start with you, Matt, and you know, can you tell us a little bit about what you observed and what you learned about the relative like privilege and power of the different actors based on sort of like how they were presenting and the identities they brought to the table when you were, you know, doing your study?
Yeah, so, you know, I think, and lawyers are well aware of this, but I think in the book, I really unpack how this comes about. But, you know, a lot of disadvantaged defendants in particular are very mistrustful of their lawyers. And the reasons for that are rooted in, you know, social position in everyday life. And so Black defendants who I got to know, Latinx defendants who I got to know, and especially who are poor, exhibit a lot of mistrust of their lawyers. That's rightful mistrust, really, or distrust, really, of a broader legal system that has proven itself time and time again to not protect them when they are victimized, but then also not, you know, treat them fairly when they are adjudicated through the legal process. And so, you know, I think the structure of the indigent defense system itself, the caseload pressure, you know, the lack of choice in assignment when they're immediately assigned an attorney at arraignment, the feeling that I had no ability to be able to make this decision because of my class position, right? I'm afforded an attorney by the court, but I have no choice, unlike, you know, someone who might be middle class and privileged has the choice through payment to choose their lawyer. And then I also think that, and I find this in the book, is that cultural distance and direct discrimination is actually pretty common in ways that, you know, lawyers that I got to know are pretty much, you know, the three who I specifically focus on in chapter 4, you know, they came in thinking about racial justice and inequality, but even some, you know, bar advocates who maybe didn't come in with that same sort of, thinking and sort of ideological perspective with respect to racism, racial inequality. You know, many of them are well-intentioned, but they do things that can be read as and do feel like and are racist. And so I think that is a problem. And I document several instances of this sort of like cultural racism, as sociologists refer to it. You know, it's not, you know, this person is inferior biologically, but it's this person is inferior because of some cultural disposition or trait, or I can't differentiate between my clients because they're all Black and I can't figure out which Black client is mine. You know, lawyers coming up when they think that, you know, it's their client who's being called up, but actually, you know, it's not their specific client. They got clients confused. And so people are obviously well aware of this, right? They see this happening, not just to themselves, but vicariously to other people in court when they're sitting in the gallery. And this breeds mistrust of their lawyers and the broader legal system as well. And then also, I think, delegitimating their community-generated forms of knowledge and expertise is also a problem, right? It's a problem in the way that, you know, clients feel that because of their social position and because of their race or their class or their gender, that they're not taken seriously by their lawyer. And this can also frustrate interactions when, from a lawyer's perspective, when I interviewed sort of the 40 plus lawyers that I talked to, from their perspective, they're just like, I know, you know, what is going to hold, right? Like, I know that this motion to dismiss is not going to fly. I know the judge is not going to take it seriously. I know that the judge is pretty much going to rubber stamp, right, whatever evidence was gathered by the police. But there needs to be a moment of translation, of conversation about why, right? About this isn't me, saying that your expertise is inaccurate. I actually agree. You have right expertise, and we should think differently about what constitutes a reasonable substance user. But in this moment, I have to do whatever works within the norms of this court process. And that conversation often doesn't happen in the everyday routine because, you know, defense attorneys are very overwhelmed.
Thanks. I mean, Portia, I'm just going to kick it to you because Matt just dropped, right, some very key sentiments about sort of like as he described, like cultural racism. And I just want to hear your take. And I'm going to take a question from the Q&A, but I'll let you start, and then I want to send you a question from some of the audience about identity and child penalty and norms and things of that nature. So go ahead, Portia.
So Matt is far more diplomatic than I am, because cultural racism, my behind, it is just straight with no chaser, run of the mill, everyday racism. But I think, just going back to, the client's experiences and what they've seen, and look, being arrested can be potentially catastrophic, right? And it creates a whole host of tumultuous situations in your life. And all many of my clients have expressed that they want is the best representation possible. Whether or not money can or cannot buy it, they just want to get up from under this situation. That's the beginning and end of it, right? But what does that really mean, right? And so, I think about something my grandmother used to say, which is like, you get what you pay for, right? And so if I, as a defense attorney, even if I have been trained, and I have, by the best and the brightest, defense lawyers, public defenders across this country, even if I walk in my stilettos ready to, kick butt and take names, my client is like, I didn't choose you. Right? So I don't trust you. I don't know you. I don't know what's what. And I think, as attorneys, as public defenders, we have to take note of that. We really have to put ego aside and really take note of that, because it will assist us in really developing a rapport with our clients. That's one layer of it. Another layer of it, and I'll keep this on the eye, it is specific to me, not all public defenders, but as a Black woman, my clients that are sitting in the audience see how Black attorneys get treated. As Dr. Claire said, we get mistaken for clients at times. Judges mistake us for clients. Officers mistake us for clients. Other lawyers mistake us for clients, and so our legal arguments may get dismissed, and our clients see this, right? And again, at the end of the day, they want the best representation. And if looking at that gives them any pause, it is on us to talk about that. It is on us to really deal with that, because I do think that communication, and I saw so much of this in the book, I saw so many moments where a simple conversation could have really facilitated a stronger rapport. But I really do think that, you cannot have this conversation without talking about how identity and race politics play into the attorney-client relationship, not just between me and my clients, but sort of what my client is seeing, whether or not it be in the courtroom or what they know about the world, right? It is not a military secret that racism exists, and my clients know that. So if my cute Black self walks into a courtroom, my client knows that there is a possibility that I may not be heard. I may not be taken seriously as my white male and or white female colleagues.
So Portia, here's a question from the audience, and I think it's relevant to what we're discussing right now about communication and communicating across lines of difference and similarity. And we have a question from the audience that's like, well, do you think, attorney-client communications and building that relationship of trust would be different if there weren't such massive, penalties on the back end of cases, right? The audience member mentions the trial penalty, and sort of like having the conversation with the client about sort of like, what are the realities of this, the system, as you said earlier, the good and the bad and the ugly of, generally crappier choices. And so, can you talk a little bit about that? And the ways in which you think, you as a Black woman lawyer navigate those types of conversations where you have to say sort of like the real about the massive penalties that someone can face, and how, you think, if at all, right, relationships would be different if those penalties didn't exist?
So again, like I see my role as really multifaceted, right? I see my role as, assisting with hope. I see my role as, trying to get the best outcome as possible. But I also see my role as giving my clients the real deal straight with no chaser. I have incredibly good relationships with my clients because of that. I don't sugarcoat any of it. And that's the thing, right? So in Dr. Claire's book, there is this moment, right, where there is an attorney that goes up to the judge and decides at the bottom of the ninth to change a legal strategy, to not file a motion that this attorney and their client had decided was going to be filed, right? That single moment could completely destroy the rapport and relationship between an attorney and a client. All the attorney had to do was simply turn to the client and say, I think this is the best legal strategy, and here's why. And sometimes as lawyers, and I think it can't be overstated, we do get focused on the forest and not the trees, right? There was an opportunity there to simply converse with your client, because not filing that motion directly impacts the individual standing next to you. And I think oftentimes as defense attorneys, we really do fall short on communicating with our clients. And now going back to what I was just saying about communicating with clients very honestly, I tell them all of it, all of it, all of it. If we take door A, this is what is behind it. If we take door B, this is the BS behind it. And I give my clients all of the information, all of it. And I'll explain it to them a billion times so that they have the agency, they have the opportunity to make the decisions for themselves. For those of you that have tuned in late, I am a client-centered lawyer. So it is my client that makes the decisions about their cases, not me. Now, if my clients want to talk about trial tax, I'll explain to them honestly, yes, this racist, classist judge may tax you. Yes, that is a real thing. I don't try to necessarily push my clients in one direction or another. If my clients ask me, Miss, what would you do? No matter how this impacts you, I'm probably going to drink it out, shop it out, talk to my homegirls. That's what I am going to do. This impacts you. So here is all of the information, right? But I may say something like, look, if you are a gambling man, and you can deal with the outcome of this case, whether you win or lose, then fight. But if you're not, then there's door number B. There's door B where I can, guarantee you that's what the outcome is going to be. That is what the plea is going to be. But if you are a gambling man, door A is trial, and this is what it's going to look like. And I take all the time that my clients need to explain it to them.
Can I just add, I think everything that Sean said is so spot on. And I think one thing that's really important for lawyers, and I think there is a subtle realization of this, but sometimes I think there is sort of a way in which lawyers sort of try to pretend this isn't the case, right? So the attorney-client relationship is happening in a broader context of other relationships. Lawyers obviously have repeat relationships with DAs. Lawyers have repeat relationships with judges. Lawyers, many of them want to move up in their profession, right? And so I think it's really difficult for some lawyers to hold that cognitive dissonance, right, if you will, of, oh, I need to be client-centered and I really, really do want to do what my client wants, but I actually think that this is a frivolous motion, or I actually think that, this might not actually work out for my repeat interactions with this ADA, or this might not work out for what I hope to do in the future, right, as I make my way through the career and the judges who I might need. And so this is, of course, not the case for all public defenders or for all bar advocates, but it is an important part, I think, of the conversation where lawyers, and I think, when I talk to young people who are thinking about becoming public defenders, some of them, when we talk about this reality of this as a profession that you're entering, and there are stages in this profession, you might have to do things or make concessions that lead to you being able to move up in the profession. Some of them are like, great, I'll be a public defender for 2 years. I just want to crash the system, rather than this is going to be my career. And therefore the things that come with this being a career, right, and may sort of like shackle, if you will, my ability to, actively, zealously represent my clients. I'm not going to worry about that. And I think that's really important. And I think that, to be frank, like there are many clients, as Portia Siobhan was saying, and who, that I talk about in the book, who it's not about mitigating the final legal outcome for them. Actually, it's really about litigating police abuse and violence in their communities that's happening all the time. I want to file that motion. I don't care if that motion is frivolous or not. I want to go to trial. I don't care about the tax penalty at all. For me, it's about maintaining my dignity, setting the court record straight, and then also potentially being able to get this police officer, off the streets, or no longer able to, have expert testimony in court because they're, delegitimated because, I've proven, through my case that, this officer cannot be trusted and is not a legitimate expert.
I think, Adiola, that is actually a point that we should discuss. Dr. Claire, you talked about a couple of things. One is sort of this assumption as lawyers that our clients' liberty is what is paramount to them, when in fact you're right? It may not be this criminal case. It may be any and all of the enmeshed consequences that come with an arrest, right? My client may not give a damn about whether or not they're going to spend another night in jail if they don't know where their babies are. My client may not care less about a state prison sentence if they are going to be deported back to a country where they don't know the language or they don't have family. My client doesn't care, or may not care about the outcome of a case, if at the end of it, they're going to lose their job anyway, or it's going to result in them being unhoused. And I think that, these conversations, especially with criminal defense lawyers, because we do get so criminal defense centered that we forget about all of the enmeshed consequences. And even as a holistic defense attorney, I can at times fall short. And I think that it is important to take a beat and really think about what is like you just said, my client may not care about the outcome of the case, and they may just want to take the police to task. They just may want to give them a couple of, right hooks and uppercuts. They may just want to take them to task on principle.
Right. New meaning to the phrase, like your day in court. Like, what does that really mean? What does my day in court look like? And I've definitely had clients who, for them, the day in court just looks like that fight that they didn't get to have, right? That objection, right? Not the standard legal objection, but just like putting words and voice to that pain, that hurt, that confusion, that disgust, that contempt, right? Because I think, sometimes as lawyers, we don't want to like style our clients as angry. We don't want to like acknowledge that our clients are mad because, those sorts of emotions shouldn't exist in the humbled, cowed criminal defendant. And I'm like, give me a break. I'm mad every day, right next to my client. We mad together, right? So there's that space in which, right, the day in court, having your day in court means something completely different to the client, depending on sort of like the nature and the dynamics of what brought them into that case in the first place. And so you got to listen, you have to tune your ear for that and figure out how you can give them like that space, how you can create their day in court for them, even if, the outcome of the criminal case doesn't look like sort of like the best of the crappy choices, right? And things of that nature. And sort of, in that sense, right, there's a question from the audience, and, I acknowledge like we're having this discussion amongst 3 Black people, right? So in this space we hold right now, right, we are not the norm in the court systems as they exist every day. We are not the norm for the attorneys who walk the space. We may be the norm disproportionately for, the clients who are facing criminal charges. But, there's a question from the audience about, well, how do you go about building trust with a client of color if you're white? And I think, I'd love to hear sort of like what your take on that would be, Dr. Claire, because I actually don't think it's so different between a Black attorney and a white attorney's ability to do it, right? Because it comes down to sort of like human interaction and what biases might be there to cloud that human interaction away from just like the normal ways humans build trust amongst each other. But go ahead, Dr. Claire.
Yeah, I think that the relationship is inherently an asymmetrical one. No matter what sort of privileges or social positions that the client has in their everyday life, even some, maybe, I don't know, some politician who's done something wrong, right? And they have a lawyer, that's even asymmetric in the courtroom, right? They may be really privileged and powerful, but also in that relationship, the court officer, the lawyer has a lot of power. Right. And so, I think, of course, when we're talking about disadvantaged defendants of color, Black people in particular, who are poor, that is going to be obviously a different power differential in asymmetrical relationship. And, I think for white lawyers with Black clients, or even for Black lawyers with Black clients, because Black lawyers have a lot of privilege, even though, they, Sybil, for example, experienced gendered racism, misogyny in her everyday practice of the court. Sybil is a Black woman who I interviewed in the book, who's a lawyer, but, she recognized that she had a lot of privilege in relation to her clients. And I think, sometimes clients will see a Black lawyer and be initially excited, as I talk about in the book. And then I show instances where that went off the rails because the Black lawyer was stereotyping them in racist ways that draw on racist stereotypes about Black criminality, Black poverty, that even Black lawyers can have and hold. But of course, with white lawyers, I think it's going to be a bit harder. So the suggestions that I have is first recognizing this inherent power asymmetry. And then the other suggestion that I have is, sometimes, and I would see this, white lawyers might do a little bit too much overcompensating that can be read by Black clients as, belittling in some way, or, trying a little bit too hard, right? To sort of show or demonstrate that you understand the racial bias or that you're down in some way. And I think just, recognizing and being humble and like really just centering the client's perspective and having a frank conversation. And I think that sort of does a lot of the work of making sure that, and then obviously just not being racist, does a lot of the work of making sure that you can start to establish a trusting relationship with your client. But it's going to be hard. And I think it's going to take a lot of work. As I followed people throughout their trajectory through their cases, I saw moments where trust would build or where it would dissipate and drive apart. And I think the important thing for any lawyer is to recognize that immediately at arraignment, when you are assigned to your client, they have literally no reason to trust you, none. And so you need to work hard to instill trust from the moment you meet them, every conversation, phone call, things that you think are quick or are not needing sort of a conversation. And to really maybe disproportionately think about doing that for your clients who are most marginalized. So disproportionately thinking, maybe I need to spend a bit more time actually with this client who is not of the same race as me, who is in a low-income community, who's experienced a lot of police violence, and sort of differentially treating your clients in that sort of positive discrimination sort of way, right? Giving a little bit more to clients who have been historically marginalized, who have experienced police violence and abuse and racism.
Thank you. And I think, you talk about seeing sort of like the dynamics at play, and I want to spend like just a couple minutes, we're nearing the end of time, right? On just like observing, right? Taking the step back that you did, Matt, and watching these interactions play out, and the ways in which like the power of observation shaped your thought process on the book. And Portia, I want you to chime in right after on sort of like the ways you observe it, in the cases that you're not involved in, as you see these dynamics play out from your seat or your perch somewhere else in the courtroom.
Yeah, as a researcher coming in with no legal background, and by the way, I actually applied to law school, I deferred, I ended up not going And then somehow I ended up getting a PhD in sociology and deciding that this was actually something that I really cared about from a different lens, right? From a sociological perspective. And so I'm bringing in those sort of presuppositions to this work and to this viewing of the legal violence that I saw as I was sitting in court. And, for me, because I'm an outsider, there are things that I think are taken for granted by a lot of legal actors that I just did not take for granted. And I think that's one thing that's valuable for the book in particular, than it being written maybe by a lawyer. Although I'm sure that people, when they start their legal careers, also maybe if you remember back to when you started your legal career, you might remember the things that surprised you or that struck you as taken for granted or routine, but you didn't quite understand why. And so for me, I think bearing witness in that kind of way as sort of an outsider, but also someone who throughout the book, I'm weaving in and out. So, sometimes I've interviewed people and I follow them as they go to court and I'm sort of sitting alongside them. I'm their friend, really. One person introduced me to their lawyer as, oh, this is just a friend who's hanging out with me. They're just here in court to support me. And so I'm really sort of centering them as I'm observing. And then sometimes I went just as an ordinary, regular citizen, just observing court as we are allowed to do and as we should be doing, right? And sort of court watching, if you will, and just seeing the quality of justice. And then other times I was sitting in the bar or in front of, in the well, right? In front of the bar, right? With the people who I had embedded with in the public defender's office in Boston. And I was thought of and treated as a member of the courtroom work group. And so there I saw the different ways I was treated. I saw the different ways the clients could have different perceptions of their treatment. And then I also got to see the perspective of defense attorneys as well. And I think that allowed me to come to a more holistic picture of the types of injustice, the layers of it, where they emerge, and the different relationships that are at stake, and the different motivations and reasons why people do certain things in the courts.
Bearing witness to this BS, it's interesting. Before I became a lawyer or a social worker, I came in to the legal profession with the baseline understanding that our criminal legal system was simply an extension of chattel slavery. That's it. And, for the attendees, I just want to be clear that that is not a conversation or a debate. Dr. Claire and Adiola can have it. I won't. But from the chains that are put on our clients to the oppressive choices that they have to make, like literally every single day has been sort of a reaffirming of this idea that our criminal legal system is simply an extension of slavery. And every single day for the almost 11 years that I have been a public defender and the years that I was a social worker before, again, has simply reaffirmed that, right? And so, reading that book was a reminder that you have to take a beat, right? And Adiola began this conversation talking about being mad at the system and being mad right along with our clients. And that is literally how, if you are a public defender or if you are a criminal defense attorney in this system, you spend the bulk of your time angry, right? And so what this book was a reminder of is that you have to take a beat. And you have to remember that there is a living, thinking, breathing individual that is standing next to you. And you chose them. They didn't choose you. And so as a result of that, there are these things that we have to do that is incumbent upon us to do, period. And if you feel like it's too much, then maybe this isn't for you. If you feel like taking a moment and having a conversation with your client and trying to figure out what it is they want, if you think that that's too much for you, you may want to examine what it is you are doing here. So what? You got a not guilty plea, but your client is going back to a cardboard box. So what? And so all that I'm saying is, in terms of bearing witness to the injustice of this criminal legal systems and the everyday fucked upness, I'm sorry, y'all that are recording this. I don't know if that's appropriate, but y'all asked me to do this panel and this is who I am. But bearing witness to this, to the messed upness of our criminal legal system and sort of walking away and not really realizing that you have to take a beat. You have to take a beat because there is a person next to you that is directly impacted. And that is why community members that are directly impacted in this system should be centered. I honestly think that lawyers really need to step the F back. And we really need to listen to our clients and really embrace this role of counselor. Nobody cares about your JD. You know, our clients have experiences that we simply don't have. And just briefly touching upon, you know, that white lawyer who wants to know how to have a conversation with their client, let me tell you something. As a Black woman from the Bronx, I was hyped to be able to represent people from the Bronx. But knowing what people know about our criminal legal system, they don't always want me as their lawyer. And I completely respect and appreciate that. But I don't try to understand what my client, like, I don't want to have the messed up ass experiences of some of my clients. What I do know though, right, and what I can align myself with is the pain that this criminal legal system causes. The injustice that, you know, police and prosecutors and judges, you know, visit upon our clients every single day. And that pain is all you need. A recognition of your pain, a recognition of their pain is all you need to develop a rapport with your client, is all you need to bear witness to what your client is going through in this criminal legal system. You don't have to be Black to relate to your Black clients. You don't have to be from the hood to relate to your, you know, impoverished clients. You don't have to have, you know, been in a domestic violence situation in order to have a conversation with your client, to represent someone that has gone through that. First of all, you shouldn't even want that. All you need to recognize is that our criminal legal system visits pain upon every single individual that is funneled through it. And if you can take a beat and recognize that, you good. That's all I got, Adiola.
First of all, I know you have more than that, but I know that's all you're going to give for right now. You're going to replenish, and then you're going to come back. Dr. Claire, you know, what are your thoughts on, and I know you spoke to this a bit, right, about what you've observed in terms of like, you know, sort of like overcompensating and the ways in which that is also detrimental, right? To hear Portia say, right, you don't need to have any of those same lived experiences. You should respect them, you should understand them, but you don't need to have any of those same lived experiences to be able to establish and build a rapport when, you know, the experience of your client is right there in front of you, right? And it is the space in which, like, you're creating a shared lived thing, live, breathing organism that is this attorney-client relationship, right? You don't need anything external. Like what obviously from your research, but just from, you know, your own human experience, right? Because we're all bearing witness to the criminal punishment system, the criminal injustice system, the criminal legal system, however you want to call it, right? As humans, when we step into that space, whether we're coming with our researcher identity or coming with our lawyer identity or anything else.
Yeah. I mean, Portia Chiffon said recognition. That's it. That is the word. I think that is what clients need from their lawyers. They need someone who is listening to them, someone who will validate that, yes, that police stop probably was racist. If you experience it as racism, then it was racism, right? That is your perspective. That's your knowledge from what you've experienced and seen in your communities. You know better than anyone else who was part of that police stop, whether that was racist or not. Right. And I think that recognition is so key. And I think because things move so quickly, defenders often don't have much time, that moment to realize, oh, wait, it's not just about how am I going to instrumentally get you to a certain mitigated legal outcome. It's also about, oh, I need to take time to just sit with you and recognize in order to build trust. And then also to understand that so much of the violence of the court system is precisely this lack of recognition from other legal actors. And so, right, so like the silencing of judges, or the judges that silence, right, the prosecutors that silence as well, the fact that you can't there's a scene in the book, and I remember just being so shocked by this moment, and then sort of really unpacking what it meant about the courts and what it means to adjudicate people and what legal violence means. There was a client who was arraigned, and he was basically like, hey, can I just, ask for personal recognizance here? And the judge is like, stop talking. Why are you talking? And he's trying to articulate the fact that the person who he was alleged to have harmed was actually in court that right there and was saying, hey, I want him back with me at home. Like, this is what I want. This is what we want collectively. And then she, speaks up at one point, she's silenced. But the process and the routine of the process necessitates that we have people who are sworn in, who are the experts, who tell us and articulate through their own voices what the client wants, and that it's not legitimate for a client to speak. And that was so frustrating, that moment of silencing. And I think that clients really need their lawyers to be at least one legal actor who's paying attention and who's listening.
Yeah, I mean, I think that was one of the earliest lessons that sort of like hit me like a wow, right? Your clients have lived the experience that brought them into this court. You're never going to have lived that. You will never know more than them about that experience because they were there, they saw it. So when they tell you something about it, right, why should you discount them when they were there and you were not? You have all the learnedness and all the books, and you've been in this courtroom before, but the one place you were not, unless somehow you are both lawyer and witness, right, is in that space where that client was at the time that all of these things were happening, right? And so you should be starting, like, as you say, right, the client has no reason to trust you at the beginning of that relationship, right? We should be coming to it with, we have all the reason to trust the client at the beginning of that relationship because they have lived the central thing that we are about to now step into this like dynamic situation to address. And so like, there is the space in which you start to live the shared experience as a human with another human, right, in that court. And it's like, that's the time to sit and listen and learn before speaking, before bringing sort of like your knowledge and your JD. Something someone said to me once stuck with me always, right? So, we're getting questions from folks, and I want to, take some time to have you all answer some of the questions that people are putting. And some of them are just affirmations, right? Someone is like, look, I love the idea of public defenders choosing their clients rather than the blind date model. And they end it with, the criminal legal system is F up, preach, wink. So, right, the people are just like affirming what you all are saying and what you all are sharing. And so, we have a question directly to you, Portia, that's, someone would like to hear your thoughts on public defenders who are jaded. They don't seem to care about holistic representation. They may be themselves just plain racist. How can public defender offices make sure that they are hiring the right folks and appropriately addressing racism from within, right? So the attorney-client relationship, right, can be molded by just like who is in the seat as the attorney. So how do we get people in that seat who bring a more dynamic perspective than what we see traditionally?
So just sort of understanding, right, like what holistic defense means, I think you can weed out a lot of people, right? I mean, you will undoubtedly have lawyers that just want to do the legal work and don't want to dibble and dabble, with any of the other social worky stuff. But I mean, at the end of the day, if you are going to be a public defender, like that is what you are going to be dealing with, whether you like it or not. And, being very clear, I think, people that are in hiring positions, we are lucky at Bronx Defenders because we have Shannon Cumberbatch, who's incredibly thoughtful about sort of, the ways in which we hire and the equity that surrounds that. But, and so I think, more offices really need to not rush to fill a position and really be more thoughtful about who it is that they're hiring and be honest about the expectations of you once you get there, right? Again, I am a huge fan. I don't know if you've noticed this, if being on a call with me, but I am a huge fan of just saying the thing. just say it, and there's nothing wrong with being clear about someone. Like, we don't tolerate racism. We don't tolerate homophobia. We don't tolerate any of that BS you're trying to bring up in here. And if you are not willing to unpack that little knapsack of yours, then this may not be the place for you. And I think that it is incredibly important for people that are in hiring positions to be honest with potential candidates about that. And directly answering the question about being jaded, let me tell you, I am a huge fan of the vacation. I am a huge, when you have to walk away, when you find yourself ready to pop off at your colleagues or anyone around you, it is time to take a step back. It is time to take a break. It does not make you a bad lawyer. It does not make you weak. When you gotta go, you gotta go. And I think it is vital. Some of the best public defenders I know, Amy Galicchio, who is a federal defender here in New York. I mean, she is the model for me for being a public defender. And I'm Jenny Semo, who also, is a model public defender for me. I mean, they take breaks when they need it, and they are bomb ass lawyers. And so that is sort of the approach that I take, when I'm doing this work. If I have to take a break, I'm gonna take it. If I need a mental health day, I'm gonna take it. And I think that it is vital. The young folks have come into these PD offices, and they're all about wellness and self-preservation. And I ain't mad at it. And I'm trying my best to take a page out of their books. But I think we need to take breaks when we need it, because we carry a lot, right? Like, all those client stories that we hear day in and day out can weigh heavy on us. And so I think that, we need to take breaks when we need it.
Thanks for that, right? It's like the system is impacting us too. Not necessarily more so than our clients, but as well, right? We are experiencing that. And so what does that do to us in successive attorney-client relationships, and what we bring to the table, and the energy we bring, and the fresh perspective we bring? How can we keep that energy up? And I think, someone has a question, and I'll put this to you, Dr. Claire, right? So the question from the audience is like, do you think that the criminal legal system, with this adversarial nature, with this punishing nature that punishes the client, punishes the lawyer, right, punishes so many, right, with all of its flaws, is something that we should be moving away from, right? And so, I'll start there with you, Dr. Clay, to talk a little bit about sort of like the system itself and its failures and its flaws, and what your takeaways were after, engaging in your study.
Yeah, I very much do think it is something that we need to move away from. And so with someone who I know, Adiola, Amanda Woog, down there in Texas, after I finished writing this book, I talked a little bit about abolition in conclusion, but then, I sort of always felt that I wanted to say more. And then this protest this summer really motivated me. And, Amanda is someone who I got to know when I was at the University of Pennsylvania Law School on a postdoc, and she's the executive director of the Texas Fair Defense Project down there in Austin. And we were having a conversation with ourselves and then on paper about what does abolition look like in relation to the court system, right? We talk a lot about police and prison abolition, but the courts are a significant component of course, the prison industrial complex more broadly that abolitionists talk about. Let's think, what would it look like to hold people accountable outside of a court process that has routinely shown itself to be white supremacist and then also exploitative on the basis of race and class as well. And so, I think, so one thing I do also want to say that I talk about in the book, and we haven't really talked about it yet, is victims aren't getting what they want. Survivors aren't getting what they want from this, as you mentioned, adversarial, right? And sort of as one of my interlocutors in the book, who he chose his name was Glasses in the book. Some people chose their names, so I gave them what their names were. He chose Glasses. So Glasses was really frustrated about the fact that he couldn't have a moment of reconciliation with someone who felt that he had harmed, that he had harmed. And, even though the parole violation so basically his alleged harm of this woman sort of led to a parole violation, potential parole violation, ultimately his parole was not revoked, and he won, right? But he felt that he didn't win, and he felt that she didn't win because now their relationship was in tatters, right? And he felt that she needed some help, some potentially mental health counseling, some support, some just help and love. And I think that's what's missing in the court system, not just for defendants, not just, of course, for the lawyers who are shielding defendants and the punishment that they see and feel from judges and prosecutors, but also survivors and victims. And so restorative justice, I think, is super important in this space. Danielle Serez's work, Fannie E. Davis's work, in Boston, Justice for Families as Healing, some of the work of the Louis D. Brown Peace Center in Boston as well. These are community-based organizations that are taking up the mantle of the failures of the criminal legal process and are articulating and organizing around alternatives, not just for holding people accountable, but also for transforming justice and making violence less common in their communities, making harm less common in their communities, and advocating and asking the government also, which has a huge role here, in stop investing in the carceral state and start investing in helping people, education, healthcare, housing, things that we've seen with the Texas crisis, right? Recently with the electric grid. What a statement of our racially capitalist system that's not investing in people and investing in profits, right? We see this all interrelated, right? It's not just the carceral state itself, but it's interrelated to the way that our government has disinvested in people and in love and in humanity.
Yeah, well, I can't, like, I'm still not ready to get into the Texas power grid failure since I lived through it. It's a thing. We don't have enough time for me to engage with what that was about, and the ways in which, like, the reverberations from it are still being felt by, obviously the folks that we serve here in my office, and the ways in which the answers are not forthcoming right now from the government about how we're going to address the complications and prevent future harm in that sense. But Portia, I want to hear your take on sort of like just outcomes versus justice, right, in public defense, and the ways in which, like, how do you measure? How can anyone measure? And Matt, I'd love to hear from you on this as well. Like, how do you measure the success of any attorney-client relationship against the backdrop of all these systemic failures?
So it depends. It depends on what my client was looking for, right? And so, when you are a public defender or when you're a lawyer generally, you are really thinking about, like, it's not necessarily about, like we talked earlier, it's not necessarily about a not guilty verdict, right? It's about maybe, bearing witness to my client completing a substance abuse program that they had been trying to complete 11 times, right? It may be that they wanted a non-incarceratory, they wanted a non-jail sentence, and we got that. Like, it may have nothing to do with, winning a trial. It may have nothing to do, like, and when I think about just outcomes, right? And just going back to this idea of sort of restorative justice, right? As a defense attorney, I represent the person that is sitting next to me, right? But also, in cases where there is a complaining witness or someone has been harmed, right? And the issue is whether or not my client did it or why my client did it. So the issue is not whether or not the person was harmed, right? That's not in dispute. It's whether or not my client did it or why my client did it, right? At the end of the trial, let's say that I've gotten an acquittal, I've gotten a not guilty, oftentimes, my client and I discuss that outcome and we don't rejoice right then and there because someone has actually been hurt. Someone has actually been damaged, and it feels weird and it feels icky. Despite getting the outcome from my client that I wanted, there's still sort of this other thing, right, that has actually happened to someone. And so me and my clients talk a lot about that, and sort of really thinking about, again, the violence that our criminal legal system visits upon everyone, right? And I love the notion of restorative justice. And I know that, we're gonna talk more about restorative justice and abolition later, maybe, but this idea that sort of there is space, there's an opportunity to reimagine a criminal. Forget the criminal legal system. There's opportunity to reimagine how we resolve conflicts that does not involve the criminal legal system, police, prosecutors, or judges, because shame on them all.
How do we get there, right? I'd love to hear your take on how do we get there, to you as well, Matt, like how do we get to that space where we're still like working from this inside and from, this very tight box of the criminal legal system?
I think it's hard when we just about, yourselves and the attorney-client relationship and in specific instances with your individual specific client. It's easier when you think about yourselves as humans, fellow citizens, people with law degrees who can use them in various ways, not just right in your individual advocacy with a client, but we see this, right? We see public defenders, staff public defenders, they work for a couple of years and they go work for, something in impact litigation or right other forms of resistance lawyering outside of sort of that try to shift and change, constitutional law and jurisprudence. And so I think that is one path, is like thinking of public defenders' offices as maybe building up people, giving them the skills. And I know some public defenders' offices do think of themselves as this way, as preparing people for that other kind of legal advocacy and work. But I also think that a lot of it has to do with just things that we do as everyday people, not just electoral politics, but also organizing on the ground in politics and communities, and sort of articulating ways through power. There's this sort of term that we talk about, Amanda Woog and I talk about, but it's really coming from the work on the ground. But we talk about and highlight how Jocelyn Simons' work and other legal scholars often talk about power shifting. This is the idea that, right, fundamentally, we're trying to shift power away from, and Justice Portia Chaffan said, right, it's not about these judges, it's not about these prosecutors, it's not about this criminal legal system. We're trying to shift power away from the criminal legal system and defining what harm is and defining what crime is and defining how to deal with it, right? And so it's really investing in communities. And, an interesting thing, I was talking to a student, I just finished a class that I was teaching called Crime Punishment America. This is the second year that I've taught it. And I was talking to a student at the end of class, and he was basically saying to me, Professor Claire, like, how do we get to this place where we don't rely on police, we don't rely on the courts, right? Like, some of it is not just legislative. And I was like, you're right. There's some things we can't legislate that people care about other people. We can't legislate that, people decide when there's a party happening next door, instead of calling the police immediately, they decide, hey, maybe I should just get to know my neighbor, knock on the door and be like, yo, Bob, like, stop having that party, right? And I think that this is, though, and I sort of framed it this way to the student, I said, this is actually a political question, though. Like, there is no clear legislation that says, like, you cannot call the police when your neighbor has a party. Maybe we could find a way to legislate that. But really, this is a moment where we really need to rethink what it means to care about other people. We need to break down and tear down a system that has us working 9 to 5 just to stay alive, right? Come home and then have no interest in interacting with our neighbors because we are so stressed, overworked, overwhelmed with this broader sort of capitalist labor market, right? That gives so much to people at the very, very top, and then makes people, the vast majority of Americans, have to work more and more and more and getting fewer gains for the work of their labor, right? For the product of their labor. And so I think this is a broader thing than just what you're doing as public defenders. And I hope that public defenders think of themselves more broadly than just their profession as public defenders. If that would be the statement there, right? Think of yourselves also as people living in this society and the everyday things that you can do and the ways that you can support organizing happening on the ground in your communities.
So I agree wholeheartedly. I am 100% in line with Dr. Claire that our relationship with the criminal legal system is freaking toxic. and it has to go. Just like any raggedy, toxic relationship that you have been in, you gotta go. You have to break up. And just like, interpersonal relationships that are toxic, we have to break up from the criminal legal system. And it has to be abolished. Now, before people's phones and computers blow up, I'm going to put a pin in abolition for a second, because I know that it is incredibly difficult for people to reimagine a world in which our criminal legal system is abolished, because we have been born and bred to only operate within a carceral state, right? We've been born and bred just to operate with, this person did something wrong, so they have to be removed. This person did something wrong, so they have to be punished in only this way. And I'm going to stick a pin in that, because, our system is not going to be abolished tomorrow. And so as we are on this road to reform our criminal legal system, I really do think that as public defenders, we need to think broader. And I'm sure many people are sticking their middle finger up at their cameras and computers when I say that, because I know that a lot of folks they just want to go in, do their legal cases, and be done with it. But I think that as our criminal legal system and our perspective shift, we do have to think about relinquishing power. We do have to think about, stop trying to be the gatekeeper of information and really think more about movement lawyering, right? When we think more about being movement lawyers and really taking direction from those that are directly impacted, right? Or organizers, or those individuals that are on the ground trying to make our communities safer and better outside of the criminal legal system. That's what I think is going to sort of get all of us free. I really think that we need to start educating the community on their rights, right? And how to safely assert those rights. I honestly do believe that we need to engage our communities more outside of when we have to go to them to sit on our juries. Maybe engage the community about jury nullification and their power to nullify. Maybe let's start really talking to our prospective jurors outside of the court. Nothing is more annoying to me than when my colleagues or somebody else come to me and only talk to me when they need me for something. So I really do believe that we need to get into this practice of engaging the community more in relinquishing some of our legal expertise and knowledge to those that are directly impacted by this work. And that is on our road. I want to be very clear, and I know my boss Ann is on this call. I want to be very clear that, my ideology is straight abolition. I think it needs to go because our relationship with it as it stands is just not working.
Thank you for that, right? I mean, I feel like I would want anybody in our society, in our country, to go and sit and spend some time the way Matt did, the way, we do, right? Just in the courts every day. They are not what you think, what you've been taught, what you've been told, what you see on TV, right? They are nothing like that, right? And I think I am not a crier. I'm not someone who cries easily. The times when I have cried have not even been in court, about court, have just been me sitting and waiting and watching other human beings experience the pain of the process, right? Because when it's me lawyer time and I have to engage with my client, I'm showing up, right? Because I understand I'm putting them first, but just watching other people experience the frustration and the pain, like brings out something in me that I'm like, this is a problem, what is happening here? And for too long, right? Matt, you mentioned, Jocelyn Simonson's work, and right, she has a piece on the ways in which, right, the public has been, excluded from the criminal legal system, and the ways in which all of that has been shrouded away. And like, if we want to give any meaning to the idea of like, having open and public trials, right, we need to start thinking about like the ways in which these processes are completely devoid of the public, right? There's no feeling more troubling than doing a trial with a client where the only people in the courtroom are you, your client, the judge, and like the court staff. And there's no one else, right? Particularly like bench trials, no juries, right? Where there's nobody in this public audience to see and bear witness to what is happening to this human being. That was a shock for me. And I don't think the shock has worn off that our courtrooms are empty in this like pivotal moment. And we're about to wrap. Thank you. I'm so glad I got to spend this last half hour with you all. This has been, restorative for me in many ways. Yeah, I'm so glad we got to do this. Thank you to NACDL. Thank you to, BPDA. And of course, thank you to Dr. Claire and always Portia Chiffon.
Thank you all. I hated to even have to like come in here and stop this conversation. And we've had the privilege of a pre-conversation with this group. And I got to tell you, there's so much more still to discuss. So with that, we're going to throw up a link in here, a QR code for our survey. You're also going to all get an email from us. Please fill out the survey. If you like stuff like this, I feel like I'm on like a PBS or an NPR thing, right? If you like this program, but you don't need to send me money. If you love this program, just fill out the survey and tell us this is what you want or what you want more of. It's how we know how to deliver what you all want. That's what we're here for. We do have 2 more programs in this series already coming up. April is Second Chance Month, and we are going to host 2 programs on race in the criminal legal system surrounding collateral consequences. So the first one is set for April 13, the next one, April 27. All of you who registered for this program are going to get an email from us with a link for how to register for that program. But we know there's so much more to discuss. So please, please, please take the survey. Let us know what else you want to hear from us. Beyond that, just so much appreciation to all of you for being so open and willing to share your feelings, to all of the folks who have attended this program, and to all those public defenders out there. Happy Public Defense Day. And with that, thank you all. Have a good evening.